they haven't picked the winner. And if they haven't, then the state legislators need to step in and legislatures need to step in. The President of the United States gave a 45-minute presentation that I think is worth reviewing this week about the various election issues. And he highlighted something that's very near and dear to Judicial Watch's work, which is the number of extra names on the rolls. And what do I mean by that? You have more names on the rolls in a lot of these states than are living there and eligible to vote. And it's a simple analysis. You take a look at what the registration numbers are, and then you compare and contrast that to the census citizen voting age population. And the latest numbers on that, I think, go through either 2018 or 2019. So it's not an exact match, but it's the best available it's the best available number set that you can review. And the numbers show that in hundreds of counties across the country, you have more names on the rolls than are eligible to vote. And of course, that's a pool from which fraudsters can operate, and also highlights the fact that the states aren't taking reasonable steps to clean up the rolls generally. And that's why it's reckless to push out mail-in balloting to the rolls, and it leads to more opportunities, as I say, for fraud and whatnot. And I think we're seeing evidence of that in the contested contests across the United States. There have been further developments. If you've been following our analysis here on Judicial Watch, you know, and we've been the leader, frankly, in highlighting, I shouldn't say the leader, a leader, because there are other good folks out there doing some great work in highlighting the role of the state legislators and legislatures constitutionally, and Congress in the electoral process, the electoral college process. For all the noise we hear about the courts, in the end, under our constitutional system, the state legislatures decide who the electors are going to be that participate in the electoral college, that picks the president. Now, if the election is compromised in any significant way, it's been my view, and it's obviously a rule of law approach, that the state legislature should step in and appoint a clean slate of electors. And I think that's something that needs to be done in Pennsylvania, Wisconsin, Michigan, Georgia, Arizona, et cetera, because of the compromise of the election process caused by the tsunami of mail-in ballots. Now, we've been warning you that this was foreseeable. The left planned on this. They wanted to set up a system in which it would kind of break our election integrity structure. So structurally speaking, the elections were broken in Pennsylvania. Structurally speaking, the elections were broken in Wisconsin. Similarly, in Georgia. I encourage you to review the Trump lawsuit filed just moments ago, I guess a few hours ago, in Georgia. It's a state action that questions the certification of the elections. And it's a civil rights case. The left only allows leftists to pursue civil rights cases, but Donald Trump, he's not allowed to pursue civil rights cases on his behalf and the voters who voted for him. But when in Georgia, for instance, you had the Secretary of State agree to send out absentee ballot applications to the entire voter registration list, more or less. And they changed the signature requirement. And this was all done with a sort of a consent decree legal agreement with the left. And the signature requirement under law is, and I'm paraphrasing here or summarizing, is that you get the signature of the ballot, of the absentee ballot, and you compare it to the signature in the original voter record. Well, they changed the rules. Not the law, the rules. Of course, the rules are supposed to follow the law, to only require them to compare the signature to the request for the ballot signature. So you could have a fraudster sign a request for the ballot and then they send the ballot to them. The fraudster signs the request, signs the ballot again. So they're essentially, under the new rule, comparing two fraudulent signatures together. And they don't go back and look at the original signature in the voter record. So when you hear the president talk about, and others talk about, a signature audit in Georgia, that's what they mean. That's what they mean. And I've warned, and frankly, everyone in the major media was warning, when you look at the rejection rates of mail-in ballots, in 2016, they were 1 or 2% in many cases, which is a big number in a close election, obviously, meaning that you get a ballot and there's a reason to reject it. Either it's too late, the signatures don't match, the ballot was filled out incorrectly, that invalidates it, all sorts of reasons why mail-in ballots get thrown out, which is why I've always encouraged people, the best way to ensure your vote is counted is to vote in person. So you had a 1 or 2%, let's say a 1 or 2% rejection rate in 2016. In 2020, during the primaries, it popped up to 3% because you had a lot of new people start using this new method of voting. And so the concern was, and the warning was, and don't take my word for it, you can go out and research it on your own. You can look at the news articles talking about the concern about rejection rates, that you would have rejection rates of 3, 5, in some cases in New York, there was a 25% rejection rate. And based on that analysis, I thought millions and millions of people would have their votes rejected. Oh, well, imagine what happened on election day. All these, it wasn't election day, it's still election, well, it's actually now election 6 weeks, right? You have rejection rates of 0.2%, 0.3%. How does that work? You know what that means? It means they weren't really checking the signatures. Or they came up with a review system that basically just washed them through without any reasonable verification to ensure the ballots were correct. So if you had in the least, you had a a mail-in ballot rejection rate of 1%. And frankly, it's probably would have been 3 to 5%, given the new people who were participating in the process. But when it comes down to it, it turns into a rejection rate of 0.2 or 0.3%. How does that work? It obviously doesn't work, and it's an indication of not only fraud, but that the rules weren't followed. And if the rules aren't followed, there's no way you can fairly certify the result. So those are one of the issues. I mean, that issue is in numerous states. I mean, we focus on the battleground states because the election outcome hinges on how those states operate one way or another. But you can be sure that issue is occurring in other states as well. So don't just because you live in a state where the election went dramatically one way, or no one's going to question the outcome, or at least the general outcome of the election. But that doesn't mean that type of insecurity didn't happen in your state or locality. I mean, there's an election for Congress in New York where there's this gamesmanship going on about ballot counting. So it isn't just the presidential race. So when it comes down to it, the courts have been not too keen to pursue the claims being presented to them by the Trump team. They filed claims in Wisconsin. The Supreme Court of Wisconsin ducked that and told them to go to the lower court, which would effectively delay the resolution in a way that would moot it out. The Supreme Court hasn't acted yet either. When you look at the key court decisions in Pennsylvania, they're just afraid of the consequences of the structural attack by the left on our election systems, because they recognize that, well, if people like Fitton are right, if people like the Trump campaign are right, if people if these everyday citizens are right, we'd have to basically invalidate a key portion of people, significant numbers of votes. And they're afraid to do it. They're afraid to do it. In some ways, I don't blame them. Now, before you go crazy, I'm just being charitable there. I think the court should do it. The law and the facts require it. But in the end, it's the state legislatures. And the state legislatures have this independent constitutional authority to designate the slates of electors. It's not only constitutional, but it's similarly referenced in federal law. I've cited to you the law before. You're supposed to pick your electors on election day, and if you don't, the states need to step in. Does anyone think those states really pick their electors on election day? I mean, I would read it to mean they can't be counting ballots after election day in a way that changes the outcome of the election. Even if you read it in a more limited way, it simply still hasn't been done in a way that fulfills federal law. They haven't picked the winner. And if they haven't, then the state legislators need to step in and legislatures need to step in. Now, in some states, you have a Democrat governor, and most of these states, I could go through each one, but there are states that there is a split between the governor and the legislative control, where you have Republican legislative control and a Democratic governor. In other states, it's a Republican governor and a Republican legislature. I'm not sure what the makeup is in Nevada, though. But in Arizona, for instance, it's a Republican governor, a Republican legislature, same in Georgia. Pennsylvania, it's a Democrat governor, Republican legislature, and I think it's the same in Wisconsin and Michigan along those lines. So some of these legislatures say they can only come into session if the governor calls them in to deal with this particular issue I'm talking about, or they can call themselves into session upon 2/3 votes. Well, that may be true for state law, but this is a constitutional issue. They have plenary power under the Constitution. They don't need the governor to tell them, they don't need the blessing of the governor to exercise this constitutional right, this constitutional power that's explicitly given to them in the Constitution to appoint electors. The governor can't get in the way of that by invoking some sort of state law. The Constitution is king in this regard. And if the Constitution is king, the state legislatures have independent authority to act. They don't need the permission of the governor to come into session to consider the issues I'm talking about. And they have a positive constitutional duty to come into session, investigate, and figure out whether the structural elections, the structure of the elections was such that they can have confidence that the alleged winner was actually the winner. I don't think any fair-minded reading of what went on in California, well, California's a whole different matter. I mean, Pennsylvania, Wisconsin, Georgia, whatever, can give any legislature confidence that the election was conducted validly. I mean, in Georgia, it was conducted contrary to state law. In Pennsylvania, it was conducted contrary to state law. So what happened here is the left changed the law, changed the rules. And that's going to result, if the law is followed, in President Trump winning. That's the way it would work. And I don't say that because I want President Trump to win. I'm not saying that because I am advocating an election result. I'm saying that because I want the rule of law to be followed. I want the law, I want the election result to reflect a lawful count of the votes, a legitimate count of the votes. a process we can be assured is reasonably free of corruption. And the way they handle these ballots, there's no way that can be assured.
Thanks for tuning in. Be sure to subscribe to our YouTube channel to catch all the latest news from Judicial Watch.